Okay, good morning, everybody. Thank you for joining us this morning. I'm Bob Danziger of Danziger Markhoff. I'm here with my partners, Christopher Meal and Michael Markhoff. And again, thank you for joining us for our program, Estate Planning and Your Retirement Plan. Michael and Chris have put together an informative and hopefully enjoyable program for you this morning. We'll get started in a moment. Most of you know us as the firm which designed, prepared, administered, and currently administers your pension plan. In addition to those retirement plan services, our firm has been helping clients with their estate planning needs since 1960. And in fact, Michael and Chris prepare hundreds of wills for clients of ours each year. So it's a real specialty of the firm. The structure of today's program is going to be a question and answer format. I'll ask Chris and Michael various questions that will hopefully elicit some answers to help you understand the estate planning process and the need to coordinate your estate plan with your retirement plan assets. We'll begin with some simple questions and then move on to more complex issues. If you do have questions during the program, please type them in the chat area, and if we have time at the end, we'll address them. If we don't have time, at the end, Michael or Chris will contact you to answer your specific question. So why don't we get started? Chris, the first question is for you. And why is it important to sign a will?
First, good morning, everyone. I hope you enjoyed the presentation and that this can be informative for you. So to start off, even if you don't have a will, everybody has an estate plan in place. It just might not be the one that you want. If you don't have a will, then your property under New York law and under the laws of other states goes to your nearest living relative. This is a method of inheritance called intestacy. So if you die without a will and you're survived by a spouse and children, the first $50,000 that you have goes to the spouse, and then everything gets split 50% to the spouse, and then the remaining 50% to children. If you have a spouse and no children, everything goes to the spouse. If you have children and no spouse, everything goes to the children. If you don't have a spouse or children, then it goes to your parents, and if your parents are deceased, to your siblings, and then nieces and nephews, and down the line. So this can create several problems if you don't have a will. First of all, you might not like your family and you want your property to pass to somebody else when you pass away. You might be in a relationship that's not legally recognized, a close friend or somebody that you're not in a civil union with or married to that you want your property to go to. Or you might be charitably inclined and want your property to go to a specific charity or your college when you pass away. And then also, and this happens more frequently, if you are survived by a spouse and children, it is important to have a will because, well, first of all, you might want all of your property to go to your spouse instead of having the property be split between the spouse and children, because you want to make sure that your spouse is provided for if you're not around. And then also, if you do have young children and something happens to both you and your spouse, or if you're a single parent, you don't want your young children to receive everything outright. And a will enables you to dictate to whom the property goes to. Not only allows you to dictate to whom the property goes to, but you can set the terms in how they inherit. So if you have young children, you can set up a trust for them. In addition, a will is important because it allows you to designate certain individuals to fill certain jobs when you pass away. So the first job would be designating somebody to be an executor. If you died intestate, the law has specific tiers of individuals that have priority. But under a will, you can designate whoever you want to be your executor. And the executor is the person who's responsible for offering your will for probate, for trying to find out where your assets are located, bringing them under the umbrella of your estate, and ultimately giving it to the beneficiaries. In addition, if you have a trust under your will, you would be designating a trustee. and the trustee is responsible after the property's been marshaled to receive it, and they hold it on behalf of the beneficiary, and they make distributions as necessary in the invested money that they had. And last, and for parents of minor children, perhaps the most important is you also are able to designate a guardian for minor children under your will. So if something were to happen to you and your spouse, or if you're a single parent, you can identify exactly whom you want to take care of your children if you're deceased.
Chris, is really helpful. And so obviously it's really important that everyone have a will signed so they can direct, they can meet their goals, I should say.
Yes.
Next question. I understand that when you and Michael prepare wills for clients, you typically include other documents, sort of the package that goes along with the estate planning documents, like a will. I understand those documents are a power of attorney, healthcare proxy, and a living will typically. Can you explain what they are and why they're important?
Sure. So these are also important parts of your estate plan. And unlike a will, these documents are operative during your lifetime. And I'll go through them in order. So the first document that you mentioned, and that's on the slide, is the power of attorney. So the power of attorney is a document where you designate an agent to handle your finances for you in the event that you can't do it yourself. Basically, you're having an agent step into your shoes. Under power of attorney, there's like a broad spectrum of powers that you can give the person that you appoint as your agent. It can be something as simple as handling basic banking transactions, like depositing money, withdrawing money, and writing checks. Or it could be something more complex where they can handle tax matters, such as filing income tax returns for you, speaking to the IRS if an issue comes up with a tax return. And then you can also have your agent handle real estate transactions and litigation for you. And under each power of attorney, the person who's designating the agent has the ability to pick and choose what powers. So generally, our clients give the full spectrum of powers to the agent. But if they're not comfortable, they can omit a certain power simply by not initialing next to a certain power on the form. There are two types of power of attorney. There's something called a springing power of attorney and a durable power of attorney. The springing power of attorney is a power of attorney that even after you sign it, it doesn't go into effect until you become incapacitated. And the way that happens is a doctor or an attending physician would make some sort of statement saying that you're of diminished capacity, and as a result, the power of attorney would take effect. More commonly used is something called the durable power of attorney. And the durable power of attorney goes into effect basically the moment you sign it and you give it to your agent that you designate under your document, and they sign it as well. And from that point forward, they have the powers given to them under the power of attorney. A power of attorney in the past 10 years or so has also had provisions related to enabling the agent to make gifts on your behalf. And this could become important for both estate tax planning and elder law planning in the event that you become incapacitated. Healthcare proxy, which is the second document on the list, is similar to the power of attorney, but not for finances, for medical reasons. So basically, with a healthcare proxy, again, you're designating an agent, and that agent that you designate, you're enabling them to speak to your doctors and make medical decisions for you. One key distinction is that a healthcare proxy only goes into effect when you're incapacitated. So, as long as you're awake and able to talk to your doctor, you don't need the healthcare proxy. But if something from as innocuous as a bump in the head and you're unconscious to a more serious condition where you're terminally ill, in that case the healthcare proxy kicks in and your agent can speak to your doctor and make medical decisions for you. Related to the healthcare proxy is the living will. And the living will is a set of instructions that you give to your agent under the healthcare proxy about what you want to be done in the event that you reach a medical condition where you're terminally ill, you're unconscious, you can't express your wishes yourself, and you're not going to get better. And basically the gist of the instructions is, please don't give me life-sustaining treatment. Let me go peacefully and as you know, as without any pain. And all three of these documents are important, and I think maybe a lot of you might have been able to infer, is that in the event you become incapacitated, and if you become incapacitated, these documents enable you to have an agent in place to handle your finances and to make medical decisions for you on your behalf. Because without these documents, then there could be major problems. The biggest of which is that you don't have somebody in place to handle your finances or make medical decisions. And as a result, somebody may have to go to court to be appointed as a guardian. Of course, this will cause delays and be quite expensive.
Great, thank you, Chris. Actually, you're up for the next question as well.
Gosh, okay.
I understand that a will may be only one part of an estate plan, and that you and Michael use trusts frequently to meet your clients' needs.
Mm-hmm.
Can you give us a few examples when you would recommend the use of a trust for a client?
Sure. So to clarify, there can be a trust under a will, and there can also be a separate document outside of a will, such as an irrevocable trust or a revocable trust. And trusts serve a variety of purposes. We'll kind of gloss over a lot of the reasons, and unfortunately, we don't have the opportunity to really go in depth in any single one. But as I alluded to previously, one of the primary uses for a trust is that if you have young children. So if you and your spouse both become deceased and you leave your property to your children, or if you're a single parent and you have young children and something happens, you don't want a young child to inherit property outright. They're just not financially responsible, and that's even the case probably for a lot of people's children who are in their late teens and 20s as well. So under a will or a revocable trust or an irrevocable trust, you would set up a trust for the child. And basically what that means is, instead of the child getting the property outright and having complete discretion to spend the money however they want, you appoint the trustee, and the trustee holds the money on behalf of the young child. And the trustee invests the money and makes distributions to the child while it's in trust for a child's education, to pay for tuition, to pay for living expenses. If the child's a little bit older, to pay for rent for an apartment, or to start a business, or to make a down payment for a home. And then when the child reaches an age where parents feel that they may be financially responsible enough to handle a fairly large sum of money, the trust will terminate, and the property will be distributed outright to the children. So that's probably the most common use of a trust that we have. But then we also often create trusts for spouses. And trust for spouses can be used for a variety of purposes. One common usage is if you're in a second marriage and you have children in the first marriage. So in that situation, you want to make sure that both your children and your spouse are provided for, but you run the risk of, if you leave everything outright to your spouse, that when they pass away, they don't give the property to your children. So by setting up a trust for your spouse under a will or a revocable trust or an irrevocable trust, you're giving the spouse, access through the trust to the money. And the way we set up the trust for spouses, often the spouse will have all of the income for the trust. They have the ability to withdraw up to 5% of the property each year from the trust. And if those two means of access to money aren't enough, then the spouse can work with the co-trustee, because the spouse is usually one of the trustees, and ask for additional money to pay for living expenses. And then when the spouse dies, under the terms of the will, the property goes down to the children. So as a result, you've accomplished providing for your spouse during their lifetime, but also ensuring that the money goes to your children at the spouse's death. And then another more technical reason that we set up trusts are for estate taxes. They're in New York, there's New York State estate tax, and there's also, for everybody in the US, there's a federal estate tax. tax. And I'll just very quickly go over estate taxes at the federal level from 30,000 feet for everybody. So most people don't have to worry about an estate tax. If all of your assets combined, house, life insurance, IRA, are below $11,700,000, you don't have to worry about the federal estate tax. And then also with the federal estate tax, you're not taxed for the amount below $11,700,000. You're only taxed on the amount above $11,700,000. So in addition to having this high exemption, this high exemption, you can give as much you want to your spouse, and there's something called the marital deduction, and that means you can give up to billions of dollars to your spouse, and you don't have to pay estate tax. Basically, the spouse receives the money, and it's assumed that when the spouse dies, that money will be owned by the spouse, and the spouse will pay the estate tax when he or she dies. However, there's an exception to that. If your spouse is not a citizen of the United States, you don't get that marital deduction. And as a result, you have to set up something called a qualified domestic trust for the spouse in order to ensure that when you die, taxes are deferred until after your spouse passes away. And also, one thing I should mention about the federal estate tax, go in line with the unlimited marital deduction, is that because if you leave all of your property to your surviving spouse and you don't use up any of that exemption because all of your property was subject to the marital deduction, your surviving spouse can actually receive your unused exemption through a process called portability. And basically, you just file an estate tax return, show that the deceased person's exemption wasn't used, and whatever exemption that they have goes to the spouse. So as a result, at the federal level, if you file for portability, you can basically give your whole $11,700,000 exemption to your spouse if you didn't use it, and then your spouse would have your exemption plus his or her own exemption when he or she passes away.
Great, Chris. Thank you for that. Michael, why don't we give Chris a break and we'll send the next question to you. Many of our retirement planning clients will accumulate significant assets in their retirement plans. What special planning do you recommend for clients with large retirement plan accounts?
So before I'm going to answer that, I just want to finish a couple things with trusts that I was thinking about. One is, one of the reasons for trusts are life insurance reasons. When we're going through a balance sheet, house, retirement accounts, savings, and life insurance count as assets. Everyone thinks life insurance, isn't it tax-free? It's income tax-free when someone gets it, but it's not estate tax-free. So, you could have millions of dollars of life insurance, and all of a sudden that could bump you up and over the 11,700,000 exemption. What do we do about it? So there's a special rule for life insurance that says if we put the life insurance into something called an irrevocable trust, a trust you can't change. And if it's an existing policy, the IRS has a funny rule that says you have to live at least 3 years to remove it from your estate. They don't want people on Monday putting insurance in an irrevocable trust and dying on Tuesday and getting a great deal. So they have a 3-year rule. So that's something we use very, very, very frequently. And the other trust that I think Chris and I spend most of our time on has to do with how children inherit. And what that's about is when both spouses die, there really are 3 options as to how children inherit. Either they get it outright, or they have a trust until certain ages where they can handle the money, like in their 30s, or frequently we use something called the generation skipping trust. Now, that's not a literal term, we always tell clients. I don't mean you're leaving money right to your grandchildren or even crazier unborn grandchildren. What it means is that there'll be a trust for the lifetime of the children where they get access to money. They can use the money, they can get income, they can get principal, they can buy a house, they can start a business. And then when they die, whatever's left over must go to their children. And then very often we have it end with the children. So why would you do this? It sounds very draconian and complicated. the main reason we do this, to cut to the chase, is to keep the money in the family bloodline, to keep it away from in-laws. What our clients are typically worried about is that child dies and gets divorced, or parents die, child gets money, and child gets divorced, that the money ends up with the in-law. Or parents die, child gets the money, and then child dies at 100 and leaves that money to their spouse, and then their son-in-law, daughter-in-law marry the lifeguards of the world. Their money ends up with someone they never heard of before. So a generation skipping trust ensures that the money stays in the family. It's basically creditor protection. We also, if in a similar vein, if children just are unable to handle money, we want to use this generation skipping trust so they don't spend it all frivolously. And also, lastly, if children have certain disabilities for which they're receiving government benefits, they need this type of trust. Now, kind of dovetailing that with retirement planning, as you all probably know, or if you've been pension clients for a while, retirement plan is one of the largest assets you have, and if it's not now, it will be, because of the power of the of compounding and growing tax-free. So what Chris and I have spent years with is how to make this retirement plan last for you, for your spouse, and for your children. And for many, many years, the plan was really one spouse leaves a retirement plan to the other. The surviving spouse lives on that plan. They receive at some point in life what's called a required minimum distribution. They have to take the money out. And that's when you're all, now the rule is when you're 72. But what happens when both parents die? We would often have the retirement plan payable to this generation skipping trust, or if there were no trust, just to the children. And up until last year, what the rule was that retirement plans can last for the lifetimes of your children. It was called a stretch IRA, or a stretch payment. It can go for the next 50 years to the children, and maybe even get to the grandchildren. What happened in 2020, at the beginning of the year, was a change in the law called the Secure Act. And the rules about this changed and made it, frankly, worse for all of us. So instead of planning to have the retirement plans last for the lifetimes of your children, we now have what's called a 10-year payout. And what that means is that when both parents are gone, the money, the IRA payment, comes into these trusts for children, and the trust has to withdraw the money within 10 years. There hasn't been any guidance as to whether it's equally over 10 years or what the frequency is. It's really by the 10th year, the retirement plan has to be withdrawn, liquidated, and given to the children, or to these types of trusts for the children. So the rationale, which I understand, but is not great for all of you and all of us, is that this was meant to be money for the worker and for the worker's spouse. It wasn't meant to be a retirement plan for children, which is how we've been planning for the past umpteen years. And last year's the prior administration decided that the IRS needed to get its day of reckoning and receive its money, so they shortened it to 10 years. There has been talk about trying to lengthen that, maybe make it 20 or 30 years. Hasn't gotten anywhere, but that's a distinct possibility. But the last point with it is, very frequently over the years, what we've seen clients do is, at 72, for many clients, since this money's grown, it may not all be needed by them or by their children. So what we've seen is that they've taken their required distribution and then gone and purchased life insurance. And if it's a married couple, they would buy what's called survivorship insurance, or second to die insurance, that would be put into the irrevocable trust I mentioned before, and would just create more estate tax-free money. So it sort of would make up for this 10-year payout if parents took the money out and bought life insurance to create a bigger pot of money for the children, and make up for the fact that this 10-year rule cuts into their inheritance.
Thank you, Michael. Michael, Chris, in the interest of time, I think I'm going to skip the next question and go to the following one. So Surya, would you forward 2 questions? Next one, that one, yeah. No, previous one. Yeah. So guys, we understand, and I'm sure many of the audience has read, that the current administration is considering making some changes to the federal estate tax law. What are those proposed changes, and what are you recommending to clients in light of this anticipated estate tax reform? Chris, I think you're up for this one.
Okay, thank you, Bob. So to start off, there are actually 2 potential changes to the estate tax on the horizon. So one, Bob, which you're referring to in the question, is something called for the 99.5% Act. And this is, it's not pending legislation, it's just a proposal in Congress. It was initiated by Bernie Sanders and a couple other Democratic members of Congress. The primary change for the estate tax that would be brought about by this legislation is that it would reduce the exemption for the federal estate tax from $11,700,000 to $3,500,000. And that's the big change. In addition to that, the proposed legislation would also remove something called the step up in basis. And this relates to for tax purposes, when you sell property, currently, when somebody dies, their basis or the I guess the amount by which like the capital gain is calculated is deemed to be the market value of the property when the person passes away. This proposed legislation will do away with the step up in basis, and even there's potential that it could force a payment of a capital gains tax as well. In addition to that, certain estate planning vehicles that we use would be made a little bit more or less efficient, such as grantor trusts and something called a grantor retained annuity trust. So that's for the 99.5% Act. In addition to that, the current exemption of $11,700,000, which was brought about by the Tax Cut and Jobs Act of 2017, has a sunset of December 31st, 2025. And that means as of January 1st, 2026, the estate tax exemption will go down from $11.7 million to roughly $6 million, which was where it was prior to the passage of this act. So as a result of these changes, for clients who could be affected by the reduced exemption, we are recommending that they make gifts now while this increased exemption is in place. And gifting accomplishes a couple of things. So first, we use the term, it's an estate tax freeze. So when you make the gift, all future appreciation of the gift is considered to be out of your estate for estate tax purposes. So if you make a gift now of $1 million and it later grows, the property later grows to be $5 million, the only amount of exemption that you use is the $1 million for the gift. Another purpose for gifting is that for the clients who can afford to make a gift, we're recommending that they make a gift in excess of the proposed future exemption. So for instance, if for the 99.5% Act were to pass, that they make a gift in excess of $3.5 million. And the reason for that is that if they're able to— You on the phone, Ernie? If they're able to make that sort of gift, then they like, let's say they're able to make a gift of $4 or $5 million. They're able to getting more down to their beneficiaries free of estate tax than if they did nothing, and the exemption when they die is $3.5 million. The IRS has already said that if you make such a gift and the exemption later goes down, they're not going to charge you estate or gift tax for the amount of the overage. And the vehicles that we're using for gifting are basically irrevocable trusts. So Michael talked about them a little bit earlier. These are trusts that you create that can't be changed once you create them. And when you make a gift, you do two things. You give up the beneficial interest of the property you're gifting, and you're giving up control. So when you transfer, but there's something called, that we most commonly use for gifting, a spousal limited access trust. We like acronyms in estate planning, so we call them SLATs. So what these trusts are, allow you to do is they allow you to make a gift to a trust, which will use part of your exemption for take advantage of this increased exemption. But because the primary or the initial beneficiary of the trust is your spouse, you're still able to indirectly enjoy the beneficial use of the property, because if the distribution is made to the spouse, it's presumably used for the married couple. So if both a husband and wife create a spousal limited access trust, they both have the ability to be the beneficiaries and also to use part of their increased exemption for gift and estate tax purposes. In addition, if you know, for instance, if you're not married or if you just want to make gifts directly to children, another vehicle that we use is something called a grantor trust, or we often call them gift trusts. And this is where basically you make a gift to a trust where your children or some other beneficiary than the spouse, some other person is a beneficiary other than the spouse. And by making the gift, you're using your exemption, getting the appreciation out. But then because it's a grantor trust, that has a specific tax meaning, which means even though the property that you gift is out of your estate for estate tax purposes, you're still deemed to be the owner of the property in the trust for income tax purposes. So as a result, you're paying the taxes for the trust. And you know, the question, of course, is why would I want to do this? So one, you're able to let the property that you gift to the trust grow free of tax. And then two, by making the contributions to pay the income tax for the trust, you're also reducing your estate, but not being charged or deemed to have made a gift. And under New York law, under a grantor trust, if the payment of income taxes becomes too onerous and you don't want to do it, then the grantor can ask the trustee for reimbursement for payment of the income taxes.
Great, Chris, thank you. Next question, Surya, is to Michael. And Michael, many of our clients are in industries where they are more likely to be sued, such as clients in the construction industry, such as medical doctors, dentists, and the like. What planning do you recommend for clients concerned about creditors?
So the interesting thing about estate planning is, besides having tax concerns and worrying about who inherits money, is asset protection really dovetails with it, because whatever we're doing for estate planning and tax treatments will also have an effect on protecting or not assets from creditors. So, you know, you're right, Bob. You know, most of our clients, most of you here might be physicians, real estate developers, or in some other profession where you feel that you're exposed to a lawsuit. What do? You know, how do you plan for it? Well, the first thing you should know is that your retirement plan, the reason why you're here on this call, is protected from creditors. And as I said before, this is going to become, if it is not already, your largest asset. And back in the late 80s, almost 1990, we actually in our office hired a lobbyist and wrote the law in New York that protects IRAs and qualified plans from creditors. We did this back then, at the behest of our clients. You know, a lot of our doctor clients at the time were worried about lawsuits. There just seemed to be a cavalcade of lawsuits at the time for usually not good reasons, but they were concerned that their biggest asset was exposed. And this is how life works. You know, we hired a lobbyist and got the law written in New York. And now, years later, every state has a similar law. So your 401k profit sharing cash balance defined benefit plan is protected. And even when you roll out to an IRA after you're at some point in life or at death, it is protected. So that's the biggest saving grace. So a lot of our clients have most of their money there, and they're always going to be fine. Now, the next part has to do with the rest of your assets. And, let me just talk briefly. What if you're married and have a spouse who is not as exposed, or if you are, there'll be different planning. But let's assume you have a spouse who is not as exposed as you to a creditor. Very, very simple asset protection planning is give the assets to that spouse, because your creditors are personal to you and your spouse's creditors are personal to them. The only time the overlap is if you have a joint debt, like a mortgage or a credit card debt, then it's both your problems. But if one of you is the physician and the other spouse is an executive at a big company and not likely to be sued, giving all the assets to that spouse will protect you, the one who's concerned about creditors. Now, the one big caveat with any kind of asset protection planning is something called a fraudulent conveyance. And Chris and I just had this recently, about a week or so ago. Client calls and says, I'm going to be sued. I did something years ago. I understand, the lawsuit papers are coming in a week or two. What can we do? And the answer is nothing. And the reason is because of this fraudulent conveyance rule. The rules exist through bankruptcy and through other laws that if you transfer money knowing that you're trying to defeat a creditor, they'll be dragged back in. And it will not work. And in fact, everyone gets in trouble for this. Not only does the client get into trouble, the advisors get in trouble for this. It's not advisable. It was something that, it comes up once in a while, not often, but the idea is you need to plan ahead. If you plan while everything is fine, you'll be fine. So very simple asset protection is give everything to the spouse not exposed. Now, if we stop there, we've only done half a job. So let's say I'm concerned, but my wife is in a profession that is not going to be susceptible to lawsuits. If I give all the stocks, bonds, house, et cetera, to my wife, we're fine. But what if she dies first? If she dies first, then it all comes back to me and it's all for naught. So what we often do is in my example, my wife's will and trust, hold everything in trust for me, because everything that's in a trust for me, creditors can't reach. So we want to have that kind of planning set up within the documents. There's also some interesting tax planning we have to worry about that we don't have time for, but we're still able to use our estate tax exemptions in that plan. And then lastly, what do we do if both spouses are exposed, or if you're a single individual and concerned? Then what we'll often do is create what's called a limited liability company, or an LLC. Different from your business. This is where we'll put your savings, your personal monies, your non-retirement monies. And the reason is under LLC rules, creditors cannot pierce an LLC. They get something called a charging order. They're able to get money that comes out of an LLC if it ever does. And in the meanwhile, while they're waiting for money to come out, they're income taxed on that money. It's like it's phantom income. So that's what scares them away. So most of asset protection is a cat and mouse game, we call it. You try to put up as many walls as you can to make it difficult. Honestly, nothing is bulletproof, but we want to make it as difficult as possible. And an LLC will do that job for a single person. A corporation doesn't do that. Just as a quick aside, if you put all your money into an S corporation, the creditor can still take the stock. But with an LLC, they can just hover out there and wait for money to come out.
Great. Thank you, Michael. The next question is, we've covered the estate planning piece of things to a certain degree. It's a dense topic, obviously, but moving on to when someone dies, the death of a loved one is a traumatic experience for everyone involved, the family, friends, and so on. Chris, what are the first steps to take upon the death of a loved one? And we have about 5 minutes left, so I'm going to need to limit you to about 2 minutes on this one, if that's all right. You got to unmute yourself as well, Chris.
Okay, sorry about that. Okay, sure. So in 2 minutes, yes, but you're correct. It's very tough when a loved one passes away, and there's also a lot to do, unfortunately. When a client contacts our office about handling an estate for a loved one of the first things we do is provide a checklist to them of both small projects and big projects that will need to be addressed during the administration of the estate. And of course, we'll help them along the way. So some of the small items would be acquiring death certificates, changing insurance for the residents if the house becomes uninhabited as a result of the death, canceling credit cards and contacting Social Security. But some of the bigger projects relate to probate. So when somebody passes away, somebody needs to be, the executor who's appointed in the will, which was a position I referred to earlier, needs to be officially appointed by the court in order to be able to marshal the deceased person's assets or collect the assets and then distribute it out according to the terms of the will. And to do that, you have to go to the state court. So in New York, we call it the surrogates court and begin something called a probate proceeding. Probate proceedings in New York take about 4 to 5 weeks on average. And then once the will is submitted to probate, the will becomes a legally enforceable document where you have to follow the terms. And then also the person who's nominated as executor is officially appointed by the court and then have the authority to contact the banks, contact the brokerages, contact any sort of institution where the deceased person had assets, and to collect those assets and bring them under the umbrella of the estate. I know I'm short on time, so I'm just going to skip right over to, in addition to marshaling assets, if there is a valuable estate where the property of if husband and wife or just is in the millions, they might have to file an estate tax return. So New York, if your estate's over $5,930,000, you'd have to file an estate tax return for New York State. And then of course, if your estate is over 11.7 at the federal level, you need to file a federal estate tax return. However, we are recommending, and I hope I have enough time to just mention this one thing, that where if a person dies and they were married at the time of their death and their assets are around $3-4 million, that even though the deceased person's asset is well below the current exemption for the estate tax at the federal level, that they file an estate tax return anyway. And this will enable the estate to elect something called the portability, which I mentioned earlier, to make sure that the deceased person's unused exemption goes over to the surviving spouse. Because this way, if the exemption later goes down to, let's say, $3.5 million as a result of the passage of the 99.5% Act, the surviving spouse not only has his or her $3.5 million, but the unused exemption from their predeceased spouse.
Great. Chris, thank you for that. Michael, to wrap up this program, we want to make sure we get everyone out of here on time. All said and done, how does the estate planning process work?
All right, it's actually pretty simple. I usually, try to explain clients. It's not that bad. It's fairly painless. I think the hardest thing is making the phone call. But basically, we have an organizer that we send to people, starting with financials. To save some time and sort of give us a little bit of a head start. Once Chris and I look at a balance sheet, we know a large percentage of how the estate plan should be set up. Because we will know what to anticipate for tax planning. So we'll send out this organizer. It takes a while to talk about it, but basically in an hour, we can go through this. We'll talk about the tax aspects and then talk about the non-tax aspects, such as the trust for children, guardians, trustees. We do everything when we're drafting documents. Initially, we do everything on a flat fee, and the answer is as doctor clients understand, it's like diagnosing a patient without seeing the patient. So once we kind of see the balance sheet, talk to you, understand what you want to accomplish, whether it's tax planning or concerns about children and creditors or your own creditors, then we'll know what we're doing and we can quote a fee. And as far as reaching out to us, you can reach out to Chris or to me. I think Chris, being the younger successor, is the point person for this group of people. So encourage you to give us a call if you'd like to go through this and have us analyze what your needs are.
Guys, thank you. The last slide, I think Surya has Michael and Chris's email addresses. That concludes our program for this morning, everyone. Really appreciate you joining us. Feel free to reach out with any questions, and we look forward to hopefully hearing from you. Thanks very much, everyone. Take care.